5 seconds to go. Start. The two money suits filed by her having been dismissed by the trial court but decreed by the first appellate court, and the decrees so passed by the first appellate court having been reversed by the High Court in two second appeals, the plaintiff appellant is back to square one and is before us in the above appeals. We have heard Shri Rajiv Bhalla, learned counsel for the appellant, and Shri Nidhesh Gupta, learned senior counsel for the respondents. The appellant herein filed two suits against the respondents herein on the file of the court of the Civil Judge Junior Division Chandigarh for recovery of a sum of rupees 10,48,000 in the first suit and a sum of rupees 67,31,000 in the second suit. The averments in the first suit were as follows: that the second respondent herein is the sister of the appellant's husband, that the first respondent is the husband, and the third respondent herein is the son of respondent number 2, that the respondents herein, defendants in the suit, were carrying on the business of dealing in building materials under the name and style of Prem Chand Amar Chand, that the appellant and her son are having a joint account in ICICI Bank Sector 9 Chandigarh, where the respondents also maintain an account, that the respondents borrowed a sum of rupees 10,50,000 from the appellant on 18th November 2003 by way of a check, that though the respondents refunded a sum of rupees 5 lakh on 7th August 2006, promising to repay the balance within 6 months, they failed to honor the commitment, that therefore the respondents were liable to pay a sum of rupees 5,50,000 towards principal and a sum of rupees 4,98,000 towards interest, thus totaling to rupees 10,48,000. The averments in the second suit in brief were as follows: that in the year 2001-2002, respondent number 1 lured the plaintiff and her husband to join him in his real estate business, that since the appellant and her family were residing in Kurukshetra and the respondents were living in Chandigarh, the respondent number 1 got the signature of the appellant in some blank papers on the ground that it was not possible to shuttle every time between these two places whenever a transaction was to be completed, that the appellant and her son were having account in the same branch of the same bank in which respondent numbers 1 and 2 were also having account, that with a view to make available necessary funds for the use of respondent number 1 in real estate dealings, the appellant and her son kept substantial amounts to their credit in their bank account. Stop.